Hey guys, I'm Luke Bouillon. I'm a real estate broker with Century 21 BJ Roth Realty Limited right here in the city of Barrie. I'm trying to do more of these videos to add value for you guys in terms of real estate and market news, community events, anything to do with Barrie and the surrounding area. So if there's a topic you want to see covered, something you're interested in, leave a comment below and we'll see if we can bring in an expert or provide the information you're looking for and add it to the schedule in the coming weeks. Today, however, we're going to talk about contract law and what it means if you make a conditional offer to purchase a property, what it means in terms of the conditions, and what it means in terms of if you want to change your mind and use those conditions to escape the deal. Is that something you can do or not? The answer is going to surprise some of you, so stay tuned. So this all came up because I've had a couple of different clients recently ask me about this or make statements in terms of, one person said, I don't need a financing condition because I have a home inspection condition. So if I don't get financing, I'll just say, oh, I didn't like the basement. Or another person said, we can go ahead and waive the home inspection because if I decide I don't want to go through with this, I'll just say I couldn't get financing. This is very dangerous territory here. Advice that some of these people have got from past agents or friends who think they know more about this type of issue than they do. And I don't want to belittle anybody here. There's many people who are not aware how this works, even many agents. When I was reason I decided to make this video actually is because I got into a very lengthy conversation last night in a online forum that I'm a member of for other real estate agents across Ontario and across the country actually, where we were discussing this exact thing, and many agents thought that yes, the condition for a financing and home inspection is written in the buyer's sole and absolute discretion. So you put that in the contract, and any reason they say I don't want to go through with it, it's my sole and absolute discretion. I don't have to give a reason. I'm out of the contract. Unfortunately, or fortunately, depending on who you are, that's actually not the case. The words sole and absolute discretion have been struck down in contract law by the Supreme Court of Canada, and this just isn't something that you can do. So what does this mean for you? Well, you have this condition, you have financing or home inspection or both. You are required to intend to fulfill those conditions. So you've put them in the offer. Now, let's say you have a financing and home inspection condition. You then decide, I want this house. It was immaculate when I visited. I don't need a home inspection. You can waive that. We can do what's called a waiver of the condition. You can forget about the inspection, proceed with the sale. That is your right as the buyer. However, the reverse is not true. You say, I just don't want to buy this anymore. I'm not going to bother to do my home inspection. You cannot do that. You are required to take the steps in the contract that you've signed and fulfill them. So you must do a home inspection. And if the home inspection is, again, we'll talk more about this, satisfactory, you must complete the agreement of purchase and sale and go through with closing on this property. Now, satisfactory, this is where the comments will come up, well, what's satisfactory to one person is not to another. Again, the Supreme Court of Canada has ruled, and this was back in 2014, I'm actually just going to check the actual case law here so I can apologize in looking this up here. It's a ruling, it was Bashan versus Hinru, and it was November 14th of 2014, where they said that based on what they're going to call common man law, what would be pertinent to a reasonable person is not necessarily what you may deem to be as important. So, this example, for example, a home inspection. You went through the property and, there was a GFI outlet missing, was one of the issues that was brought up last night as just a point of example. They're about $40, $150 installed by an electrician. The buyer says, no, it's missing, my absolute discretion, I don't want to go through with this property. The courts and the judge will say this is not a pertinent defect for a $300,000, $400,000, or $500,000 home. It's not a large enough amount to be material to the purchase of the home. It is not something you can use to disallow a home inspection or to not fulfill your conditions as part of the deal. The same thing goes for financing. So, I have my sole and absolute discretion on financing, and I couldn't get financing that was satisfactory to me. If you were looking for a rate of 3% and the best you're going to get offered is 3.5% because of your credit or this, that, and the other thing, again, I'm sorry, that is not a material reason to not fulfill your financing condition. You would have ought to had a pre-approval and known what kind of rate you were going to pay, and from there you entered into your agreement of purchase and sale. Now, if that, for example, you thought you're going to get a standard mortgage, and for whatever reason you cannot be approved, you've tried every avenue, and the best you can come up with is a loan shark who's standing behind you with a pair of cement shoes and is going to charge you 50%, break your kneecaps. That's different. That is a material reason where you would not be able to fulfill your financing conditions. So these are things that are on a case-by-case basis, but it's important to know that if your reason is not deemed to be applicable to a normal situation, you may be disallowed this by the court, and you can be sued for a sizable sum of money for not closing this transaction. When it comes to the home inspection, this is even more muddied by the fact that even if the issue you found is material, let's say you come in and it turns out there's large cracks in the foundation and the basement is leaking, this would be something that's probably considered material and should be rectified. But if the seller then offers to do this and pay for those repairs before closing, again, as a buyer, you ought to accept that. You do not have a legal right, at least in Ontario, to forfeit this agreement of purchase and sale, because this item is going to be rectified for you. So you ought to continue with the purchase as you intended. Now, again, people tell me, well, my agent said no problem. I can just go ahead and get out of the deal. I have this discretion. Well, unfortunately, this isn't my opinion. You can go ahead and take that advice, but what I'm telling you is that you can be sued. Your agent can probably be sued as well, but definitely you can be sued for not fulfilling this transaction. So I just want you to be cautious in terms of taking these advice, because there is very established case law that is known in Ontario. And I've actually reached out to a lawyer who wrote a very good article on this that I wrote last night, and I've asked him for permission to repost that to my blog. If they respond, I will be putting that up, and I'll put a link below this video. But search for the Bashan versus Hinru, and you will see many articles citing the exact details I'm going over with you here in terms of what is allowed and what isn't. And it's just very important to know that while this isn't always enforced by the seller, it definitely can be, and you're open to legal litigation if you're not following through with the contract. You're owed what's called a duty to perform, and you said that you were going to purchase this home as long as these conditions can be met. You are required to go through all reasonable steps to make sure that they can be met. It is not a get out of jail free. It's not a collect, pass go and collect my deposit back, as someone mentioned. This is an item where you made an offer to purchase this home, and unless there's a reason where you really cannot, you should be purchasing this home. And this is what the Supreme Court of Canada has decided. And this is, it really does protect everyone, and it keeps everyone honest in terms of you're not tying up a buyer's property where they're losing other offers when you are not serious about purchasing the property. So it's important for both sides. And there's some responsibilities on the seller's side as well. They have to, follow the same duty to perform in terms of allowing you in for the inspection, in terms of, doing what they can. Both parties in a transaction are owed a duty of care to each other to advance the transaction. So definitely read up on it. Hopefully I'll get that blog posted. If you have any questions, comment below. If I can't answer them, I'll reach out to a lawyer who can, and we'll post a reply. Thank you very much, and thanks for watching.